Hello there and welcome. This is the Disability Law Show. So good to have you back with us this week. If it's your first time, we're talking about disability law, but it's a very complex topic. You might not know much about it, but you may need to at one time or another in your life. So we're so good to have you with us. Tamar Agopian is joining me, courtesy Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. You want to reach out, just have a chat beyond the half hour of the show when you're going to be learning stuff. You can do so, 1-855-821-5900. Email is help@disabilityrights.ca. Some other contact and websites we'll get through over the course of the half hour. Plus, we're going to get to this topic a little later on, preparing for the IME, the Independent Medical Examination. Never heard of it? Never been through one? Again, that's why you're here. And you're going to learn in just a bit what that's all about. That and some emails we'll get through as well. But we always start off with Tamar with a week that was story. What do you got?
Week that was.
Yep.
And so this week I wanted to highlight an individual who has contacted me a second time. Long story short, after she has appealed twice and has not been able to get her benefits reinstated. So let me provide a little bit of background of her situation. She's in her late 40s. She worked in a medical type setting, like a medical type assistant setting, and she developed some symptoms for which her doctors really didn't know what was going on. Dizziness, fatigue, shortness of breath, coughing. She had falling down incidences, brain fog, a series of symptoms which put together were creating a profile where she established she was totally disabled. And actually, in her situation, while she was being investigated as to what was happening, the insurance company actually approved and paid for a period of time.
Okay.
So they agreed, look, because of the setting that she was in, given the symptoms that she was experiencing, they actually agreed that she met the test of total disability. But as insurance companies do, they got impatient. And they did not want to wait out to see what the diagnosis was, to see what the course of treatment was. And they just took the position they always take, which is, look, we paid you for a little while, but now we're coming up to the change of definition. We don't think that you're totally disabled from doing any occupation. And because of this new lens and this more rigorous test, we're going to cut you off. And so, to her credit, not only did she try and advocate for herself in terms of trying to get a diagnosis, which she did, but she thought by virtue of getting this diagnosis, she would try an appeal. And I think in certain rare instances, John, when you've got a new or developing health issue, there could be a limited instance where I might say, fine, submit that medical information to the insurer, see whether or not they're going to do right by you. But guess what? I'm right. She did not get nothing. She got nothing. She did not get approved again. Her benefits have still been in the cutoff mode, and it has been a year. 1 year for her to have gone through multiple appeals. She now has the expert on her condition. It's called CIRS. I'm going to read it out. Chronic Inflammatory Response Syndrome.
Okay.
Turns out that she had significant mold exposure some years back.
Come on.
No word of a lie. And her doctors have now concluded that she has this condition. And the condition can be treated, but it's a prolonged, multifaceted treatment plan, which is expensive. So not only did she now get the diagnosis, she's now got a treatment plan. Her doctors are saying, if we put you on this treatment plan, you're expected to get back to work within a year, maybe two. It's not going to be forever, which is what she wants. She doesn't want to be off on disability, but she wants the support of the disability insurer. And this is what the disability insurance policy is meant to do. It's supposed to be a peace of mind policy. That's what the courts have said. This is what all disability lawyers know. It's supposed to be there to provide you with the financial support while you're figuring out what's happening from a health perspective and hopefully focusing on your recovery. What added insult to injury for this poor woman is the fact that not only has she gone through multiple appeals, but they also refused to cover the treatment. Now, this is partly because the disability insurer, when they put their disability hat on, John, they're only thinking about disability benefits, income support benefits.
Right.
They're actually not necessarily considering the treatment offers, because that treatment could potentially be another arm of the insurer or perhaps an extended health care plan that you've got with a different insurance company. Having said that, though, you would think in a situation that I've described that it would be in the best interest of the insurer to offer that treatment support, pay for that treatment plan, give her the LTD benefits, and see it through so that she can get a resolution and eventually get back to work. But there's dollars associated with that. And as we know with insurers, the driving force is always profits, and they did not do right by her, which brings me full circle to the appeal process. And I think this is where it really does highlight, look, you're going to go through a lot of frustration. Let that be my problem. I don't want you to wait a year before you get your disability benefits. I also want to get you some additional compensation if you need it for treatment and other efforts. And this is exactly what we're doing for this poor individual. And like I said, she and I spoke some months back. She thought by getting the diagnosis and getting that information over to the insurer that might change their mind. Fair enough. She's absolutely in her right to do that and go through that appeal process. But the vast majority of people will be declined again. And they have lost an incredible amount of time and, frankly, a lot of frustration, John, in having to deal with the insurer themselves on top of everything else.
I find it amazing that, and we've talked about this on our radio show, which, by the way, we've been doing for over 10 years with you and Savan and the rest of the team, is the insurance industry, long-term disability insurance. It's the one thing either you and your employer pay for. You give them money, but you get nothing in return unless they don't want to give it to you. It's like buying a new car and the salesman, I'm going to give you the key. You may pay for it, but you're not getting the car.
I think that's the worst part of it, is that you have paid into this disability plan for years. Or perhaps it's a copay situation with your employer. If you've got a group plan, perhaps it's a private plan or a group plan. But either way, you're paying a monthly amount to the insurance company to have this coverage. And when we see this resistance by the insurance company time and again, and then dangling that carrot to say, hey, and you should appeal. You should stay within our process to go around the block again to try and prove to us that you're sick enough that we should give you that benefit. It just, the whole profile of it doesn't sit right with me, which is why it opens the door to so many adverse decisions against the insurance company. They know that this is not a winning proposition, doesn't look good before the eyes of the court. But what I find worst really is that I want to be afforded the opportunity to help. And I think that the vast majority of people, when they go through this with the insurer, they're worn out, they give up, they leave money on the table, and they don't know really what their rights are, which is why we do the shows, as you said, radio, television, lots of resources, absolutely free. There's no obligation, and just inform yourself, because frankly, before you're going to go down the path with an insurance company for a year, at least have a conversation with me or someone on our team.
You know, we've talked about it in the past ad nauseum, the appeal process, but I think it's kind of worth mentioning again because you brought it up, because it's such an elephant in the room when it comes to LTD. And it's appeal. It sounds like it's something very legal and governmental on the outside of the insurer. So I have to do this because it's an appeal, and I stand like they're throwing me a life jacket, but it's made of lead and it's full of holes, and I'm going to sink to the bottom. Right. People don't think about that, right? But it's all within the company. It's all within the insurance company.
It is, and usually what you're ending up with is the same person who reviewed your file the first time, looking at it at least a second time, and it's human nature. It's human nature that if you've denied a certain claim or have a decision about a certain claim, you're not going to be persuaded necessarily very easily to do a 180 and change course, especially since you've now, as an adjuster, checked off that box to say to your boss, hey, by the way, I closed this one out and that one out and that one out. And so I do think that it can be stacked against individuals just because the process is the same insurer, the same adjuster, maybe someone in the next cubicle, same group of people looking at it. There's not a lot of oversight. And most disability policies don't have the word appeal in it anywhere. So it creates no checks and balances, even from a legal perspective, as to what needs to happen in an appeal process. There's no set time frame for them to respond to you. There's no obligation for them to put fresh eyes and review the claim again. And what you're doing, essentially, is running down that clock to actually start that legal claim. Because it's important for people to know, in most jurisdictions across the country, you have only 2 years to sue from the first moment the insurance company denied you. So imagine if they've taken a year to get you through appeal after appeal, you've now lost a year. You've lost a year where you're entitled to benefits, where you could have allowed the legal process to actually be started and finished. John, sometimes we can resolve these claims in a matter of months. And so, look, I can understand that it can be overwhelming, but at least find out what your rights are, know what your options are, and if you need to come back to us, we're not going to get insulted or upset or embarrassed or anything like that. We're here. talk to us 4 times, and if it's the right choice to move forward, let's do it.
You may have caught our sister show, the Employment Law Show, at one point or another. We talk about and focus heavily on Pocket Employment Lawyer, pocketemploymentlawyer.ca. Why? Because it's a really handy and useful website in that regard. But there's a very robust piece in that website, Tamar, about disability law. Talk to me about it.
So this is a plug and play. I say this week upon week, that it is an easy tool, very simple to put certain pieces of information in, and it will pop out a little bit of an analysis to let you know whether you've got a basis for a long-term disability claim or a short-term disability claim or potentially an employment claim, and whether or not it makes sense in those circumstances to actually have a conversation with us. What's helpful about the tool is that it's absolutely anonymous. It's very easy to use. You don't want to do anything with the information afterwards. Click off your browser, you're done.
Yep.
You're never going to be contacted by us at all whatsoever. But if you want to understand, look, could this be a potential starting point? Do I have a case? Is there something I can do here? This is an excellent place to go, pocketemploymentlawyer.ca.
DisabilityRights.ca, the firm website. Go there. I believe it's still at the top. It says Knowledge Center. You click on that. There's a drop-down menu. It'll show you the media tab. We do radio shows across the country as far as the disability law show is concerned. You can tune into those. They're an hour long. You also have the opportunity every week to make that phone call into the show and talk to us. Want to get to a phone call from one of our shows tomorrow. We're going to play it back now and talk about it a bit.
Absolutely.
I have been off work now for 3 years, and I've got long-term disability for 2 of them. I'm actually fighting it now to get my benefits reinstated. Now, if at some point I get better, does the company have to take me back on my job?
Great question. Great question.
Excellent question.
Common.
And so, look, I want to actually talk about the disability part of the question first, which is, he's describing to us that he's fighting to get his disability benefits approved. And in my mind, when you've been off work for 3 years and you've got your LTD benefits were cut off after 2, it's likely the perfect scenario that we talk about every time, which is the insurance company saying you are no longer totally disabled past that change of definition. This is what I expect is happening in this individual situation. And for those who might not be familiar with it, your disability policy likely has 2 tests to qualify. The first part is, are you totally disabled from your own occupation, your own job that you were doing before you became unwell and your doctor put you off work? After a couple of years of benefits, though, that test to continue to qualify for long-term disability changes. And it arguably becomes a little tougher to meet because it says, is there anything you could do, anything in the world for which you've got the basic education, training, and experience that would put you into a job that would pay you roughly what your long-term disability benefits pay you? And as we know, LTD is only usually about 2/3 of what you were making. So the threshold for earnings is low, and the test for any job in the world is also low. So a lot of the times we see disability insurers cutting off otherwise legitimate claims in this time frame. Why do they do this, John? It's a deterrent, because they do want to put that pressure on you trying to canvass either going back to your own job or a different job.
Yep.
But at that point, the insurance company actually doesn't really much care. They don't care if you go back to the original job that you had, because they've already approved and paid you for what the own occupation period of that policy is. So in my mind, if the doctors are still supporting that he remain off work, that he's not capable of doing any type of occupation in any setting, then the answer is to keep challenging the disability insurer. But use our help to do that. We can start a legal claim. We'll get to point A to B with the insurer very efficiently, very quickly. As I talked about at the top of the show, doing the runaround with the insurer isn't going to get you very far. And then let's deal with the employer. Because in a situation like this, he's worried about not being taken back by his employer.
Yeah.
Absolutely fair worry. And generally speaking, your job is not necessarily guaranteed, but your employer does have a duty to accommodate you. So think of a scenario where he is well enough to return back to work. What I recommend for people is, look, broach that with your employer directly. Put in a medical note if you need any kind of restrictions or limitations. If you need to work through with accommodations with your employer, they have a duty to do that to the point of undue hardship. And you have to cooperate with their efforts in finding you a job that fits within any ongoing restrictions and limitations. But it's not a forever guarantee. And what I find generally is that if you've been off work for a period of time, your employer may not want to terminate you in a situation like that because it opens a can of worms on human rights issues and other things. They may work with you, but if they don't meet that duty, that could actually expose your employer to a potential claim. And then you may be entitled to severance in a situation like that and other avenues. And so this is where we're really well suited, right, John? And especially myself and a few others on our team, we work in both disability litigation and employment litigation. And so when you've got a situation like this where you're not really sure where to go, do I continue to pursue the disability insurer? Do I pivot and deal with my employer? Let us help you work through those options to optimize and to optimize compensation. Because at the end of the day, that's really what you want, is to make sure that the right people are paying you for the things that you're obligated to receive, and you're exercising your rights to get those benefits.
We will take a short break. What you need to know if you're about to attend an IME, an independent medical examination, that is on the way on the Disability Law Show. Stick around. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Disability Law Show, reaching out anytime to Tamar Agopian and her team. You can do so. The phone call easy, 1-855-821-5900. Help at disabilityrights.ca. That's the email address we go to all the time and bring them on the show as well. Our main topic, what to do, preparing for the independent medical examination, the IME. First question, what is it?
What is it? Good one. The independent medical examination is basically an assessment. It's an assessment that's being done by one of the insurance company's own selected doctors or specialists or experts. And they're going to review and assess the claimant and have the doctor provide a series of answers and essentially a report at the end of that assessment as to how the individual is doing, both from a health perspective, return to work planning, all of that. But John, this is a hired gun, okay? Let me not mince words here. This is a hired gun by the insurer meant to provide a certain type of answer, okay? Because the insurance company is not going to spend money on an IME, an independent medical examination, if it's not going to actually lead to a closure of the claim at the end. So this is not someone who's going to necessarily give an individual a fair shake. So I want people to understand that, yes, they are most likely required to attend, they have to participate in the process, but they should know that this is not a treatment providing situation. This is strictly a doctor who wants to know in a point of time and answering the insurance company's specific questions on whether or not you can get back to work and when.
You mentioned the claimants attending. Are they able to refuse to attend an IME?
Generally speaking, I would say no. Now, you do want to understand what's involved in the assessment, what type of assessment, and I'm getting ahead of us a little bit in terms of the points to cover off with an IME, but the reason why you want to understand it is because you want it to line up with your actual health issues. So if you've got a physical disability and the insurer is sending you to a psychiatrist for a review, you've got to scratch your head and think, hang on, what's the disconnect? That doesn't necessarily make sense. And the vice versa is also true. So if you've got a mental health disability, but they're focusing on a physical assessment, and they're going to test to see how long you can sit or stand or lift, but your job has nothing to do with any of those requirements, and it doesn't make sense, then I think it does make sense to challenge your adjuster and say, hang on, wait a minute, what type of assessment are you getting me to go here? But most disability policies will say, if we think that you require some kind of assessment, we're going to set you up for that assessment and you must attend. Because if you don't and you do refuse, you run the risk of your benefits getting cut off prematurely before that assessment is completed and the insurance company can do their full analysis.
Again, we're talking about what you need to know if you're heading for an IME, the independent medical examination, and exactly that. Okay, now I know I have to go, so I'm going to go. What can I expect in preparation ahead of time?
Absolutely. So number one, you want to know when. Yeah. You want to know where,
nice.
Right? And the where, let me pause on the where for a moment, John, because if it's going to be a fairly long trek for you, the insurer actually has an obligation to arrange transportation.
Wow.
So depending on where they're asking you to attend the independent medical examination, you want to make sure that perhaps transportation be arranged, perhaps a car service. I've known one client who actually had to get on a plane to go to a different city. No joke. And so you want to prepare yourself for all of that because, look, there could be a lot involved. You know, yes, the extreme example is getting on a plane, but it could be a couple of hours away. So bring food, bring water. You know, there's some basic things that you want to arrange. Perhaps you want to bring someone with you as a support individual. So these are the nuts and bolts. There are more general things, though, as well that I recommend. The one that's the most important is really getting your doctor to be in line with the fact that this IME is happening. Your doctor needs to be aware. They need to be aware as to what, when, how, and be part of the conversation around getting a copy of the report once the IME is completed. Because I'm projecting here, most of these IMEs will say, this person is fine, they can get back to work. It's your doctor that's going to be able to provide further medical information to support the ongoing disability claim.
Who's actually been treating you.
Exactly right. And so sometimes with the IME process, you've got to sign an authorization. That authorization may or may not include sending a copy of the report to your doctor. So part of the preparation is really looking at the fine print, making sure you understand very clearly the what, the when, the how, and making sure that your own doctors are involved in the process.
We're going to take another small break, get back into some more emails. We might have something to do with an appeal, possibly. We'll go down that road almost every show, it seems, but it keeps coming up, right? That is help@disabilityrights.ca if you want to contribute one for a future show, and we will continue. This is the Disability Law Show.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Disability Law Show. We also want to give you the number anytime. You can reach out to Tamar and her team. She's got a great team behind her, always willing to help. 1-855-821-5900. Tamar, first email, well, not first email, but we'll get to another email here for the show. That is help@disabilityrights.ca. Natalia says, my brother has been battling several health issues for the past few years, including alcoholism. His application for LTD was denied, as the insurer said. He submitted his application late. His employer later acknowledged that this was not my brother's fault, but the insurance company still refused to approve his claim. We've been advised to appeal the decision. What should we do?
Don't appeal the decision.
That's it. Have a good night.
Exactly. Mic drop. Because here I see, John, a number of technical declines.
Okay.
What does that mean? Number one, they denied on the basis of late notice and proof. So most disability policies have a specific period of time in which you need to apply for disability benefits. In Natalia's brother's situation, she describes that the employer actually had a hand in that tardiness. And if that's the case, courts have said, in fact, that you can get what's called relief from forfeiture. It's a technical rule that says, look, if you had imperfect compliance with the timing of your application, the court will forgive a short delay, especially if there was a reasonable explanation, which it sounds like there was in a situation like this. But insurance companies like technical declines, John, because it alleviates their obligation to actually look and take a hard look at your disability claim. And I think what concerns me with Natalia's situation is that her brother has an alcoholism, substance use and abuse condition that's part of the overall disability picture. And insurers don't like these types of claims. They don't like it because they know that they can't really rely on exclusions in their policy that says, if your disability arises from a substance issue, we don't need to pay your benefits. And I'm telling you, every policy has this, even though these are valid disabilities. So instead, if they can find technical reasons to decline benefits, they will do that. Or they will dress up declines in other ways and say, look, you're not getting appropriate treatment, so this is why we're going to decline your disability benefits. Either way, there are a few logs on the fire here, and I don't see the insurer being deterred from their ongoing position of declining benefits in a situation like this. You really do need a legal claim and a lawyer. Have us talk to the other lawyer of the insurance company, talk to them about these issues, because they're going to know the cases, they're going to know the law like I know the law and our team knows the law, and we can exert the right pressure to actually get the compensation, as opposed to going through that wheel of appeal and being denied again and again based on these technical grounds.
I will give you one more website you can refer to, in fact, ask questions anonymously and absolutely free, called mydisabilityquestions.com. Remaining minutes, we'll get to this one from William. Tamar, he says, I was receiving LTD benefits for a while and started seeing a psychotherapist that the insurer recommended. I was encouraged to engage in outdoor activities like hikes and golf, but then the insurance company eventually used that against me to cut off my claim after conducting surveillance. I'm still not well enough to work. What can I do?
Really good question. Look, William, I mean, I've seen surveillance be used, as a sword by disability insurers. In their minds, this is like damning evidence that you must not be truthful about your level of activity or function. But the key here is that William was endorsed by his own medical team to do these activities. Right. And so if that endorsement has been put in writing, and if that's been put over to the insurance company, surveillance is a no, never mind, John. It's not actually a proper basis to decline an otherwise valid disability claim. And in fact, courts have agreed, judges have agreed, it's not persuasive. So if I'm William, I want to make sure that medical information is in front of the adjuster, that they're looking at it comprehensively, and frankly, that they're really calling us and starting a legal claim, because adjusters get emboldened by surveillance, even though the courts have said it's not really something that you can rely upon when there's an otherwise valid disability claim.
Because surveillance generally for the insurance company is costing some money.
That's right.
They want to get some benefit from it, right?
They do. And so they will really only try and do it if they think they can bring a hasty closure of your disability claim. And so the challenge I have here is that I want to understand whether the insurance company actually had information that was consistent with what William describes. Because if it's consistent, there's nothing untoward with him participating in these activities and saying, but I'm still not well enough to work. Here's the endorsement from my doctor. My doctor is aware of all the things that I've been doing. In fact, the things that I've been doing were therapeutic. They had a benefit from a health perspective, and I'm on the path of recovery, but not quite there yet in order to be able to get back to work. So when I see these kinds of situations with surveillance, I'm actually critical of the disability insurer who perhaps was not looking at the claim in a good faith basis, but a lot of cynicism, trying to attack the credibility as opposed to looking at, look, does this line up with the information that we have? And upon which, by the way, he was approved and paid disability benefits for a period of time.
I'll ask you this in our last minute, that all that surveillance information they have, you have access to it? You have to, right?
We do get access to it if we're involved. Right. And so if we're involved and it was obtained while the adjudication was happening, then we get all of it. We get the video, we get the reports, we get all of that information. And I think what's really, really compelling is if they only observe William 2 out of 19 days that they tried to surveil him, guess what? I'm going to be throwing that right back to the insurance company and saying, this is not representative of his level of activity, and you have an improper basis for declining his claim.
That is it for another show. Thank you so much for sticking with us. You want to reach out to Tamar and her team anytime. Phone number is first, of course, 1-855-821-5900. What we just read that from was from mydisabilityquestions.com. Then there's always the email, and that is simply help@disabilityrights.ca. We'll catch you next time on this show and catch our radio shows as well. Thank you so much for joining us here on the Disability Law Show. We'll catch you next time.